2190. Common law offence of misconduct in public office. The common law offence of misconduct in public office provides that it is an offence for a public official, in the course of or connected to his or her public offence, to willfully misconduct himself or herself by act or omission without reasonable excuse or justification, where such misconduct is serious and meriting criminal punishment, having regard to the responsibilities of the office and the officeholder, the importance of the public objects for which they serve, and the nature and extent of the departure from those objects. R.V. Quach, 2010, 27 VR 310 at 46, Obud VR, 2015, NSWCCA 309 at 133, Shumkwokshire VHKSAR, 2002, 5 HKCFAR 381 to Sir Anthony Mason MPJ. The offence extends to politicians, such as a member of the New South Wales Legislative Council, Obud VR, 2015, 91 NSWLR 226 at 123, 125. Members of Parliament are entrusted with certain powers and discretions on behalf of the community, and they must be free to exercise those powers and discretions in the public interest, unfettered by considerations of personal gain or profit. Horn v. Barber, 1920, 27 CLR 494. Perrottet J. The system of government expects, and depends on, individual ministers to do the right thing. R.V. McDonald 2017, NSWSC 638 at 239. As a common law offence, the penalty for misconduct in public office is at large. In such instances it is the practice of the court to adopt an analogous or corresponding statutory offence, where available, as a reference point for the imposition of penalty. Blackstock VR, 2013, NSWCCA 172 at 8, citing R.V. Hockin, 1922, 22 SR, New South Wales, 280. However, the courts have emphasized that a statutory analogue is a point of reference only. It does not establish a kind of de facto maximum. Blackstock VR at 59, Jansen VR, 2013, NSWCCA 301 at 51. The penalty for an offence of being an accessory before the fact to misconduct in public office is also at large, as an accessory before the fact is liable to the same punishment as the principal offender. S. 346 Crimes Act 1900. The same approach of sentencing having regard to a statutory reference point, as set out in R.V. Hockin, may be applied. Jitrawong VR, 2011, NSWCCA 168 at 5. The misconduct in Jitrawong VR involved the offender corruptly receiving payments whilst acting as the manager of a registry of the RTA. Both the offender and the Crown accepted that the relevant reference point was Part 4A Crimes Act, which provides for offences of corruptly receiving commissions and other corrupt practices, which carried a maximum penalty of 7 years imprisonment. Jitrawong VR at 6. Assessing objective seriousness. Given the offence can cover a wide range of conduct, the circumstances of a given offence and offender are likely to vary enormously. It is not helpful to attempt to break the offence up into artificial subcategories. Jansen VR, 2013, NSWCCA 301 at 64. The court said in Blackstock VR, 2013, NSWCCA 172 at 14. By way of explanation of the rationale for the offence, Doyle C.J. said in Question of Law Reserved, Number 2 of 1996, 67 SASR 63 at 66. It is clear, I consider, that a offence strikes at the public officer who deliberately acts contrary to the duties of the public office in a manner which is an abuse of the trust placed in the office holder and which, to put it differently, involves an element of corruption. It may be that the mere deliberate misuse of information is sufficient to give rise to an offence, but the further allegation of an intent to receive a benefit clearly, in my opinion, brings the matter within the ambit of the common law offence. The statement of the purpose of the applicable rule of criminal responsibility assists in the task of assessing the objective seriousness of the offending in this case. See also R.V. Quach, 2010, VSCA 106, 2010, 27 VR 310 at 44,47, and Attorney General's reference, number 3 of 2003. 2004, Eucocrim 868, 2005, 1 QB 73 at 55,61, were relevant. The amount of money involved is a highly relevant consideration in assessing the objective seriousness of the offending. Blackstock VR at 63. In that case, the offender had channeled government contracts to a company he had specifically established for the purpose, and the level of profitability indicated a degree of abuse of office involved. Blackstock VR at 63. However, the offence need not involve monetary amounts to be objectively serious. In Hughes VR, 2014, NSW CCA 15, a police officer improperly accessed the COPS database for illegitimate purposes, passed on the information so gained, and failed to report admissions to crimes to appropriate police officers. The offending was correctly characterized as of a high level of objective seriousness. Hughes VR at 50, Jansen VR, 2013, NSW CCA 301 is a further example of the offence involving access and dissemination of confidential police information. In the case of misconduct on the part of a politician, the damage caused by the offence is not measured by any material loss to the state or gain to the offender. The real harm is the damage caused to the institutions of government and public confidence in them. R.V. Obide, number 12, 2016, NSWSC 1815 at 84, R.V. McDonald 2017, NSWSC 638 at 231, 237, 238. The offender's conduct in R.V. McDonald in exercising power conferred by a statute, as a minister, for an improper purpose to confer a benefit on a third party was found to be a serious example of the offence. R.V. McDonald at 249. As a breach of trust is not part of the definition of the offence under common law, it does not constitute double counting for a sentencing judge to have regard to that factor. Rather, it serves to emphasize the degree of departure from the proper standard that must be established. Blackstock VR at 61, citing R.V. Quach, 2010, 27 VR 310 at 44. A very significant matter in the assessment of any level of criminality is the nature of the duty owed and the extent of the breach. The more senior the public official, the greater the level of public trust in their position and the more onerous the duty that is imposed. R.V. Obide, number 12, at 79-88. Mr. Obide's offence was regarded by the court as a very serious example because of the onerous nature of the duty owed as a parliamentarian compared to other officials, and the extent of his departure from it. R.V. Obide, number 12, at 89. General deterrence, denunciation and recognition of harm done to the community were the dominant considerations in determining the appropriate sentence. No penalty other than imprisonment was appropriate in that case given the nature of the offending. R.V. Obide, number 12, at 138.